what to do. The Employment Opportunity Commission is responsible for enforcing federal laws that make it illegal to discriminate against job applicants or employee because of those protected classes, right? Race, color, religion, sex, pregnancy, gender identity, sexual orientation, national origin, age, over 40, disability, or genetic information. Um, uh, Andrew Hager had asked the question: could a retaliation also help those who are, or I assume, could retaliation also help mean retaliation protection? Also help those who are physically and mentally disabled. The EEOC is going to be, um, the primary body federally who's going to fight for those things, right? So if you are, you know, if you have some kind of disability, whether that be physical or mental or social or whatever, if you've got some kind of disability and you feel that you're being discriminated against, the EEOC is who you're going to look to, right? And most businesses are required to have EEOC information and OSHA information, posted. Um, and so, to kind of get to what I think Andrew's question was, could it help those of us who are physically or mentally disabled? The EEOC is what who protects you there generally, although the other agencies most certainly have overlap into it. So the protection already exists. Retaliation is about when you file with the EEOC and say, I'm being discriminated against because of my disability. Um, and then your employer fires you or demotes you. That's where retaliation comes in. And all of these agencies have protections against retaliation. So if you file an OSHA complaint, if you file an EEOC complaint, and then you face negative impacts in your work, all of these agencies have, opponent or have components to them to and kind of legal standing that retaliation is illegal. Um, So it'll also protect us from prejudice of able-bodied and neurotypicals. Yes and no, right? This is where the situational dependence really comes in. Where these laws really protect you is from your employer, but right, you are protected from discrimination based on those protected classes, and so this is kind of where I said earlier, hostile work environment isn't that your workplace sucks. It's that there's discrimination based on protected class, and there's rules on what rises to the level of discrimination. So someone, saying something shitty doesn't necessarily rise to the level of legal discrimination according to labor law. When you start adding things in, like you've asked them to stop being being prejudiced, it's been addressed. When you establish that it's a pattern, those things, kind of each one of those boxes you check opens the door further and further for potential action. And especially, I feel like we've really kind of seen a move in the last few years or decades, where businesses are moving in the right direction gives them too much credit, because they're mainly covering their asses. But I feel like in general, businesses have become better over time about protecting their employees from inter-employee prejudice and disputes, because of the fact that if my coworker is discriminating against me for one of the reasons of the protected classes, and I can establish that it's a pattern of harassment. I can establish that the workplace isn't doing anything. Now that employers really open themselves up to legal trouble, right? Now I can file a lawsuit against them. And so we're not in a good place, but I do think we've been slowly moving in that a better direction, as DEI, diversity, inclusion, equality, and DEIA, diversity, equality, inclusion, and accessibility, becomes more and more the norm, especially in larger businesses. Now, we see states like Florida trying to ban that stuff, right? So it's not universal. It's very location dependent, but the protections are largely about your employer, and to get to the level of what is considered legal discrimination, it's got to be kind of repeated, and they've been told to stop, and reaching a level of harassment. OSHA, the Occupational Safety and Health Administration, was formed to assure safe and healthy working conditions for working men and women. OSHA gives the OASF, the Occupational Safety and Health Act, gives workers the right to a safe and healthful working condition. It's the duty of employers to provide workplaces that are free of known dangers that could harm employees. OSHA is empowered to serve as the regulatory and enforcement body in this regard. So if you are a cook in a fast food restaurant and there's no air conditioning in the middle of the summer and your kitchen is 120 degrees, OSHA is kind of who will help you in that realm. If you're a steel worker and you don't have protections, if you work in an Amazon plant, right, or an Amazon warehouse, OSHA's your friend here. Same for like FedEx and UPS. That's who's going to kind of deal. OSHA's who's going to deal with those safety issues. So like the Department of Labor is going to be your broad. The NLRB is going to be more about organizing. The EEOC is going to be about discrimination. And then OSHA is going to be about safety. And like I said, all of these have a level of overlap, right? They're a Venn diagram that isn't doesn't have isolated silos. So most of these also, I'll say most of those types of agencies also exist on a state level and even a local level, right? So you can have these conversations, with the federal and as well as state agencies to help you, get moving on getting justice.